Hello and welcome to VisaMate, your comprehensive resource for U.S. immigration updates and guidance. Today we'll be discussing the latest announcements from U.S. Citizenship and Immigration Services, or USCIS, including the fiscal year 2026 H-1B cap initial registration period, new organizational account enhancements, important final rules for H-1B and H-2 visas, updates to EB-2 national interest waiver policy, and changes to Form I-140 filing procedures. Let's dive right in. First, fiscal year 2026 H-1B cap initial registration period. USCIS has officially announced that the initial registration period for the fiscal year 2026 H-1B cap will open at noon Eastern on March 7, 2025, and run through noon Eastern on March 24, 2025. During this window, prospective petitioners and representatives must use their USCIS online accounts to register each H-1B beneficiary electronically and pay the $250 registration fee for each beneficiary. If you're an employer looking to file an H-1B cap subject petition, you'll need to create or use your organizational account in the USCIS system. If you previously had a registrant account for H-1B seasons before fiscal year 2025, for example, fiscal year 2021, fiscal year 2024, but didn't use it in fiscal year 2025, your old account will convert into an organizational account the next time you log in. For any first-time filers, you can create an account anytime. Just make sure you're ready to register your beneficiaries starting March 7th. Further, legal representatives can add clients to their accounts anytime, but both representatives and registrants must wait until March 7th to enter beneficiary details and submit the registration along with the fee. There's no advantage to racing to register on the first day because USCIS will randomly select after the entire registration period closes on March 24th. By March 31, 2025, USCIS will notify petitioners and representatives via their online accounts if any of their beneficiaries were selected. Additionally, one key point about the fiscal year 2026 H-1B cap is the Beneficiary-Centric Selection Process launched in fiscal year 2025. This means unique beneficiaries will be chosen rather than multiple entries for the same individual. Once enough unique beneficiaries have registered, USCIS will randomly select among them. If registrations are fewer than the numerical cap, all properly submitted unique beneficiaries will be selected. In addition, to streamline the payment process, the U.S. Department of Treasury has approved a temporary increase in the daily credit card transaction limit from $24,999.99 to $99,999.99 per day during the fiscal year 2026 H-1B cap season. This change addresses previous issues where high-volume registrations exceeded the daily limit. For any transactions over $99,999.99, USCIS advises using automated clearinghouse payments instead. Keep in mind, some banks require advance notification to remove ACH blocks, so plan ahead if you anticipate large payment amounts. USCIS will provide more details about this process before the registration period opens in March. Furthermore, new organizational account enhancements for fiscal year 2026. To make filing easier and more efficient, USCIS has introduced organizational account enhancements for fiscal year 2026. Key improvements include paralegal accessibility. Paralegals can now work with more than one legal representative. This means a single paralegal account can handle H-1B registrations, Form I-129 petitions, and premium processing requests for different attorneys. Easier client invitations. Legal representatives have a simpler way to add paralegals to a company's clients. Pre-population of form fields. Certain Form I-129 fields will now automatically fill based on selected H-1B registration information. Spreadsheet upload of beneficiary data. Organizations can prepare a spreadsheet of beneficiary details and upload it to pre-populate data in H-1B registrations. Look out for these features going live before the start of the initial registration period. Second, H-1B Final Rule, H-2 Final Rule, and revised Form I-129 effective January 17, 2025. Moving on to another major update. January 17, 2025 marks an important milestone in U.S. immigration policy. On this date, the Department of Homeland Security will implement two final rules and a revised Form I-129. The H-1B final rule modernizes the H-1B visa program by streamlining adjudication processes, increasing flexibility for employers to retain skilled workers, and enhancing program integrity through improved oversight. The H-2 final rule aims to strengthen protections for H-2A and H-2B workers by imposing new penalties on companies that charge prohibited fees or violate labor laws, and offering greater flexibility for seasonal and temporary workers under these visa categories. Additionally, USCIS will introduce a revised version of Form I-129 effective January 17, 2025. This edition of Form I-129 reflects updates necessary to align with the final rules. Importantly, there will be no grace period, meaning outdated versions will be rejected after the deadline. If you are planning to file Form I-129 on paper, pay close attention to these rules. The April 1, 2024 edition of Form I-129 will be accepted only if it is received before January 17, 2025. If the April 1, 2024 edition is received on or after January 17, 2025, it will be rejected. Starting January 17, 2025, USCIS will only accept the January 17, 2025 edition of Form I-129. These changes were officially published in the Federal Register on December 18, 2024. To avoid delays or rejection, ensure your paperwork is accurate and up to date before filing. For more details, visit the USCIS official website and stay informed about the latest immigration policies. Third, USCIS updates guidance on EB-2 National Interest Waiver petitions. We're also covering the latest USCIS policy update regarding the EB-2 National Interest Waiver, also known as NIW. This update, released on January 15, 2025, clarifies eligibility criteria and the evaluation process for immigrant petitions filed under the Second Preference Employment-Based EB-2 classification. What is the EB-2 National Interest Waiver? In general, an EB-2 petition is filed by an employer using Form I-140, Immigrant Petition for Alien Workers, after obtaining a labor certification from the U.S. Department of Labor. However, USCIS can waive the requirement of both a job offer and labor certification if the petition serves the national interest of the United States. Key point: unlike standard EB-2 petitions, individuals applying under the NIW category may self-petition, meaning they do not need an employer to sponsor them. Who qualifies for NIW? A petitioner seeking a national interest waiver must first prove that they meet the EB-2 eligibility criteria under one of these two categories. 1. A professional holding an advanced degree such as a master's or doctorate. 2. An individual of exceptional ability in the sciences, arts, or business. What has changed? The new USCIS guidance clarifies. For advanced degree professionals, USCIS will assess whether the occupation itself qualifies as a profession and whether the required 5 years of post-bachelor's experience aligns with the specialty field. For persons of exceptional ability, USCIS will evaluate whether their exceptional skills, knowledge, and expertise directly relate to the proposed endeavor. This determination will be made on a case-by-case basis, evaluating national importance and supporting evidence. To approve an NIW petition, USCIS must determine that the proposed endeavor holds national importance. This means it must have a broad impact on the U.S. economy, society, education, technology, healthcare, or other vital fields. USCIS will assess letters of support, business plans, and other evidence to determine whether the petitioner is well-positioned to advance their proposed endeavor. Special considerations for STEM professionals and entrepreneurs. This update builds on previous USCIS guidance addressing STEM professionals and entrepreneurs. It recognizes that scientists, engineers, and technology experts often make contributions that benefit national security, economic growth, and innovation. This policy update is effective immediately and applies to all NIW petitions pending or filed on or after January 15, 2025. This new guidance is part of Volume 6, Part F, Chapter 5 of the USCIS Policy Manual and supersedes all prior guidance on the topic. For more details on the EB-2 National Interest Waiver, visit the Employment-Based Immigration Second Preference EB-2 section on the USCIS website. Finally, USCIS updates filing procedures for Form I-140. USCIS has announced updated procedures for filing Form I-140, especially when accompanied by a permanent labor certification, Schedule A designation, or an NIW request. Starting June 1, 2023, the Department of Labor introduced the Foreign Labor Application Gateway (FLAG) system for permanent labor certifications, along with a revised Form ETA 989. Employers using FLAG receive a 2-page final determination from DOL electronically. For Form I-140 petitions with a permanent labor certification processed in FLAG, you must include a printed copy of the DOL's electronically signed final determination, considered as the original labor certification. That final determination needs to be signed by the foreign worker, the employer, and the employer's attorney or agent, if applicable. Schedule A petitions require a completed uncertified Form ETA 9089, all relevant appendices, and a signed final determination, plus a valid prevailing wage determination tracking number in Section E, Item 1 of the Form ETA 9089. EB-2 National Interest Waiver or NIW petition requests require a copy of Form ETA 9089 Appendix A, a signed final determination. This Federal Register notice doesn't change how USCIS handles these petitions. It simply makes sure the public is aware of new documentation requirements for labor certifications under FLAG. That wraps up our comprehensive review of the latest USCIS updates. From the fiscal year 2026 H-1B cap registration period and beneficiary-centric selection process, to the new H-1B and H-2 final rules effective January 17th, and the newly updated EB-2 NIW guidance. These changes reflect an evolving landscape in U.S. immigration policy. If you have any questions or need clarification, feel free to drop them in the comments for more in-depth articles and resources. Remember, it's crucial to stay informed and ensure your filings are done correctly and on time. This video is for informational purposes only and does not constitute legal advice. For personalized counsel, please consult a qualified immigration attorney. Thank you for watching. Be sure to subscribe to VisaMate for more updates on U.S. immigration news, tips, and resources. We wish you success in your immigration journey.